Okay, well, I'm going to get started. It's 2 minutes past the hour. I want to welcome everybody to this webinar on the coronavirus response programs and how it affects entrepreneur-operated businesses. Our guests are Jason Myers, and he is the owner of Meyer Business Law, and his law firm is dedicated to the legal needs of entrepreneurs and the businesses they run. Jason's going to focus on what the new grant and loan programs are available to entrepreneurs and small businesses, including solopreneurs and consultancies. He also addresses other legal implications of the pandemic, including structuring your business and contracts for disasters and interruptions. And I'm Ayesha McCabe. I'm the owner at First Steps Financial, and we are a virtual bookkeeping and accounting outsource services for small businesses. And I will be talking about, should you be applying for the loan? And then if you do get the loans, what actions do you need to take after that? Ayesha Hamilton is the owner of Hamilton Law Firm, and her firm focuses on the practice of employment law. She's going to talk about the new laws and the regulations affecting employers and employees, including sick leave and payroll, and how they specifically affect small businesses, independent contractors, and consultancies. And I'm going to turn it over to Jason, and we can get started with his information.
Hi, everybody. Thank you for joining us. Hope everyone's well and staying dry and all those good things. Let me share my screen and start the PowerPoint. Alyssa, are we good there?
Yep, looks great.
Excellent. Hi, everybody. So I'm going to take first position. Alyssa's gonna come afterwards with some reactions. Ayesha will join when she gets off the line with the judges. And what we're going to try to do here is to leave plenty of time for your questions and your specific concerns. So, I'm going to go through kind of quickly. Let me just say, as a general matter, there are a lot of details in these programs. There are a lot of ins and outs and finer points. I'd rather address those in response to your questions than just to be throwing out numbers to you. And of course, the main thing is any of the three of us, Alyssa, Ayesha, and I, are available to you afterwards. For the next several weeks, for the duration. If you have any questions, call first and let us know what's up, or send us an email. And we'll do our best to point you in the right direction. We definitely want to be a resource for the communities that matter to us. Who the heck am I? I'm the founder and principal lawyer of Meyer Business Law, which, as Alyssa said, is a law firm that I started dedicated specifically to entrepreneurs like me. I have been a serial entrepreneur and led 4 different companies and been on the C-suite for 3 different additional private equity funded companies. And I'm a proud member and sponsor of Tiger Labs, whose image you can see virtually behind me. Hi to my fellow Tiger Lab members. I miss you too. What I want to talk about today is to quickly highlight the New Jersey and the US relief programs for entrepreneurial operated businesses, the ones that are most relevant to our kinds of businesses here in coronavirus world, and give you an overview of those and some of the issues in particular that may stand out to the kinds of companies we all run. And then as time permits, there's some other legal impacts that I thought would be useful for you to hear, particularly as they affect the contracts you rely on and the continuity of your business. As I said, we're here to answer your questions. The best way to pose them is to go to the chat or Q&A at the bottom of your screen and start typing. Type at any point, and Alyssa is going to be watching the screen and presenting your questions to us as they come up. Disclaimer at the bottom of your screen, I'm not your lawyer yet. This is general advice. Don't take it as specific legal counsel. Okay. What's going on with the state of New Jersey and the New Jersey Economic Development authority, the NJEDA. New Jersey has done a pretty good job of creating programs specifically for entrepreneurial operated businesses. There is, there's a limitation to it. The state of New Jersey, unlike the federal government, cannot just print money. And so there's a budget. They know their budget's limited in this respect. They know that the state's income is going to be dialed back with everything else going on. So the pool of money the state has to offer is pretty limited, and frankly, at this point, is probably all used up. But I still want to tell you about some of these programs, particularly as they may still be available and most relevant to you. One thing is that something the state has been especially good at, I think, has been to present information, and I've been just really impressed with how the Murphy administration is doing in terms of keeping people informed. Let me let you know about two resources in particular. One is the website cv.business.nj.gov. That is a portal that the state EDA has created to be a central point to get information about these business relief programs and other issues affecting business, and especially small businesses and growing businesses in the state. It's a good portal, a lot of links to articles and information. The other site is assistance.business.nj.gov, and that is a wizard, a questionnaire that the state EDA has created, and you can go in and just answer questions about your business. How is it owned? How many employees? Where are you located? Things like that. Not questions you need a lawyer for. Just answer these questions, and it will bring up the programs that you're most eligible for or that may be of most interest to you. I have run it through for both of my businesses, and it worked great. And it gave me different answers for the two businesses, which were appropriate. And it provides links to both the state and the federal programs. So it's a pretty good starting point. And given the haste at which things were assembled, I was really impressed with it. I recommend it to you. So NJEDA is running two main emergency assistance programs. One that will provide grants of up to $5,000, and another that will provide loans of up to $100,000 for businesses with half their employees in the state, with a physical location that's not a home in the state. These programs are really designed to keep people employed. And I have to say there are a couple of reasons why they're probably not right for most of you on this call. One is they're pretty tapped out. All expectations are that money's already gone. I think they're closing the door on some of them officially today at the end of the day. Although they may reopen them, they may dedicate more funds to them. So what NJEDA says to do, if they're of interest to you and you think they're a fit for your business, go ahead and apply. It can't hurt. You'll be in the queue. If they find more money down the road, you'll be the first that they contact. But do be aware that these programs are really designed to keep people employed. So if the nature of your business is, it's just you and you take a draw, or it's you and some independent contractors that you pay through 1099, a couple of people, the state's not going to be that interested in your business. They're primarily interested in larger employers, still small businesses, but places where they can keep people off of unemployment. The more interesting thing from the state may be the loan guarantee programs. One program that will provide a 50%, where the state will guarantee to 50% a working capital loan you get from premier lenders, and another program where the state will guarantee up to 80% of a working capital loan you get from existing investors. These are ways the state is trying to keep the flow of capital going to businesses like the ones we run. So for example, if you already have some angel investors or venture investors, and that could include you, it could include, parents, friends and family rounds. There's no limit on that. It doesn't have to be an official, institutional lender. It just, a private investor who's investing in your company has 25 or fewer employees, less than 5 million of revenue. If they've already put money in, they can lend more money to the company now if it is in response to the virus, and the state will guarantee 80% of that loan, really cutting the risk for those lenders. It's a very powerful program for those of you who have companies in that position, and you may want to look into it. Okay, let's move now to the SBA and the federal loans, the things coming out of the CARE Act, the thing that you've been hearing in the news, that there are these programs and that some of that $2 trillion is going to small businesses. These are the main programs. And you may have heard a lot about these, so I'm gonna try and stay with the commentary on these and not the nuts and bolts. The program that's, I think, getting most of the attention is the PPP, the Paycheck Protection Program, which is an SBA loan program through banks. You apply to the bank, not to the SBA. You have to apply to an SBA approved bank for a low interest loan, which is up to 100% forgivable. You don't need to put down a personal guarantee on this loan if you qualify for it. The loan is really intended for your company to be able to continue to pay people it has been paying. It is aimed at the situation that the pandemic hit, everyone gets sent home. Rather than firing people, how do you keep them on payroll? Or rather than dumping your independent contractors that have been with you and are kind of like employees, how do you keep paying them? This program is coming in two flavors. One is for, quote, small businesses and sole proprietors. That really means, to me, businesses that are small businesses but have W-2 employees, standard payroll employees, or sole proprietorships, as in you don't have a business entity. And where you're paying yourself through a W-2. In some cases, 1099s might count. That's kind of confusing. That flavor of PPP, the rules were that program opened up last Friday, April 3rd. The rules for it were not announced until late on April 2nd. Some banks did not announce how they were going to process these loans until April 6th. This is all breaking news. But if you have a company that like mine, frankly, you get paid not through a W-2 by yourself or not through a K-1, but you just take a draw. You're transferring money from your business account to your personal account, and that's how you get paid. And you're reported on a Schedule C on your 1040 return. That makes you self-employed under this program. You can get a PPP loan. How? We don't know. They're opening up that program tomorrow. They haven't announced all the rules. The banks haven't announced all the rules yet. We just know there will be something for so-called self-employed entrepreneurs. And this is also where the remedy is supposed to come for independent contractors. People have been paid regularly on 1099 basis. The program's been a confusion. The computer system at the SBA crashed. There may not be enough money for it. Just as evidence that there's a problem, Senator Warren was already out yesterday with her plan for how to fix it. Like or not, my point is clearly there's ample evidence that there's problems going on with this program when you see that there is already, only 4 days into it, a lot of chatter about how do we fix it. So some of the issues are, when do I get it? How do I apply? Where do I apply? Some banks are ready, some banks are not. Some banks have wacky forms, and I've started to get comments from people about that. We don't know yet what the rules are for self-employed companies. A couple of other things to note for you. There is a Buy American clause within this loan. So if you're the kind of entrepreneurial business where you're doing something like, hey, I am people's connections to factories in Asia. I am a connection for people to use, a call center in the Philippines. You might have a problem with the Buy American clause. It might be completely antithetical to the nature of your business. If you are VC backed and you're part of a portfolio of a large VC and they have a lot of companies, the affiliation rules that define whether you qualify might come into play. It's kind of unclear how 1099s come in, but they're probably not part of payroll. The main thing is that, the appeal of this is that the loan may be forgiven, but it's only forgiven to the extent, mostly, that you spend it on payroll. These rules are kind of complex. If you're really counting on this loan being a grant and not a loan, you need to really look carefully at these rules. One thing is the Federal Reserve has announced it's opening a new facility to support the lenders who are granting these loans, so that smaller community banks will be able to issue lots of them without worrying about what it does to their balance sheet. So that's the PPP. And then the other program is this EIDL, the Economic Injury Disaster Loan. And this is actually a program that exists for things like, hurricanes and earthquakes. It's a FEMA kind of a program. If you're in a disaster, and all of us in the country are officially in a disaster, then the SBA will issue you a low interest loan. Not as low interest as the PPP. This one's at 3.75%, still a pretty good rate. And you don't need to guarantee it to the extent the loan is under $200,000. Here's what I find most interesting about the EIDL. Number one, you don't go through a bank. You just apply directly online. There's a form on the SBA website. It takes about 5-10 minutes. It's pretty straightforward. And boom, you've applied. You're in the queue. Now, the queue may take a while. People who applied last week, the ones I know of, still haven't gotten an email back or anything else from the federal government saying that it's in process. But it's an easy application, number one. Number two, if you check off in that application that you're interested in a $10,000 advance on the loan, that $10,000 advance is forgiven. It is not to be repaid. It is essentially a grant. So the bottom line to me here is, I think for almost any kind of business, if you feel comfortable certifying to the government that you have been negatively affected by the pandemic, and you can prove that in some way when you're asked to, I think there's pretty much here $10,000 of free money from the federal government by asking for it. We'll see if that's how it bears out, but that's certainly what it looks like. By the way, this is not mutually exclusive with the PPP. You can apply for both programs. If you do, you have to be careful, like, which you put in which bucket and how you try and get reimbursed for payroll. You can get into those details when it matters. The main thing is these programs are available to you. I'm actually gonna, let me just pause there for a minute. Alyssa, anything you want to add about these programs before I get into the other sort of legal implications of the pandemic?
Have to unmute myself first so you can hear me. We actually have, Ayesha's in, great.
Good timing.
Yeah. So we have some questions that pertain to what you're talking about. So would you be okay addressing them now, or do you want me to hold till the end?
I don't want to, let's try and do both. Let's take a few now, and then seeing if we have time available at the end, we'll take a few more. So maybe a couple of the most generally applicable ones.
So this is a question that someone asked, and I believe it's going to answer a lot of people's questions. So someone owns a business. They have 13 employees, but they don't pay themselves a paycheck. They take an owner's draw. Mm-hmm. So do they, when they apply for the PPP, does it make sense? Do they put their, Schedule C in there too as part of the payroll loan? I know.
Good question. And I don't know that we have the answer to that question yet. Here's what I would say. It's Thursday now. It's Thursday the 9th now. Tomorrow, the 10th, the self-employed part of PPP gets released. And when it does, we'll see what they say about how they're defining self-employed companies, mm-hmm. and how companies are supposed to treat things like owner's draw. And I hope that will become clarified as of tomorrow. So I'd kind of say at this point, wait the 12 hours Let's see what they say tomorrow about self-employed companies, because as between the way that owner and their company, that relationship, that's a self-employment relationship. And you'd kind of like to count what you're paying yourself, because you'd like to be able to continue to pay yourself, and you'd like the loan that you take to continue to pay yourself to be forgiven. So I wouldn't want to trip that up.
Right. But they would have
if
to
it's not
apply.
clarified, frankly, what I would say is apply, count your draw, and then at some point, hopefully in the near future, you'll be in a conversation with a bank. You'll go through the SBA, you'll go through the details with the bank before they lend you the money, and you and the bank will straighten that out.
Right.
That becomes easier the more you're dealing with a bank that, number one, knows you, and there's plenty of advice that you should be doing this. There are banks that are taking all comers, but most banks are saying we're only doing this with our existing customers.
Right.
I think given the lack of clarity about this program and the number of people applying, it's really in your best interest, if you can, to deal with a bank, not only where you've got an account, but where they actually know you. There's like a human being who deals with you.
Mm-hmm.
My own preference is pretty strongly for a community bank, or maybe your credit union in this situation, rather than a big mega bank, because you're going to need to have conversations with people to get this right.
And on the other end, when you have to do the forgiveness on the loan, the forgiveness is based on the bank.
Right.
The bank has the ability to forgive the loan and decide what they would forgive.
And I've gotten an email in advance of this webinar from someone dealing with a large mega bank, Bank of America, and they're having a problem because like the form doesn't really match what's going on, and what the computer spits out in terms of paperwork isn't 100% right. And you really don't want that. You're signing a contract that says you owe money. You'd like it to be correct.
Yeah.
But how you fix that with a Bank of America when it's a computerized form, good luck.
Is there?
Our lights are flickering here, just to let you know.
No.
At
That
any
means
point,
it's coming this way.
uh,
I just have one more question. Do you know if the EIDL grant is taxable?
um,
You can chime in too if you have information. I don't think that it is, but I'm not sure on it. We can always.
I think to the extent it's a grant, it might. To the extent it's forgiven, it may be taxable. Typically, forgiven loans are taxed, but they may have special provisions in for it, and I have not run that one to ground.
And they've thrown all the normal things out the window.
Yeah.
So, as we know, so who knows? Okay. Well, you know what? We'll look into it. And someone asked about the self-employed, which I think you answered. And so go on, and we'll keep up with the chat box and see if there's any more questions.
Quickly, let me just throw out some other legal implications of the current universe. And again, I'm going to be pretty quick on these, but I want to issue spot for you. And then if you see something that you think is of particular interest to you, hey, reach out and we'll talk. Number one, remember, let's talk about contracts, and the contracts your business really depends on, like the piece of paper between you and your client, the piece of paper between you and, let's say, key vendors or key contractors, or maybe your landlord. First rule to remember, in a contract, almost everything is negotiable. The two sides to a contract can pretty much always agree to change the rule in the contract. So nothing in the contract's written in stone as long as you and the person on the other side of the contract agree to make a change. And this is a time when flexibility is certainly at a premium for both sides. No one really wants to see their business go away. Most landlords do not want to see people leave. Most contractors do not want to raise a fuss that means they have no work. You can make changes, and an exchange of emails where both sides clearly agree works in a pinch. But just remember to be flexible, and that your contract is not a barrier, it is a vehicle to that flexibility. A lot of talk recently about what are called force majeure clauses, act of God clauses that say, in the event of a catastrophe, an act of God You don't have to perform. You're forgiven if you can't match the contract. These clauses are actually often much more complex than they really need to be. They may not be a liberator. They may be a problem. Watch out for them and don't depend on them unless you've really checked it out. Some things to look out for. Look out for auto renewal clauses in your contracts, and remember that that includes all the things you buy online on a subscription basis. They may have specific dates about when those contracts expire, when they auto renew. And in this environment, you might not want them to auto renew. You may not want to pay that, whatever it is for that software license again, or for that, next month's gym membership, or whatever it is. But a lot of contracts just, auto renew because everyone loves recurring revenue. Remember to look out for that. Look out in the contract for the ways you have to give people notice of things. And remember basically that words matter. If someone says, hey, I'm going to give you a forbearance on what you owe me, that doesn't mean they're forgiving it. It means you don't have to pay it today, but you're going to have to pay it later. It's a debt. If someone says, we'll defer it, you still have to pay them. So these little word choices matter a great deal in terms of whether you're getting the relief you want or not. Finally, in this world, this is a good time to get your house in order. Just like you've subscribed to Zoom, or go to meeting, or my favorite Uber conference, whatever it is, just as you've gone to that virtual world, your contracts should go virtual with you. There's no reason they can't. There are ways you can set it up so the contract itself, along with your delivery, become virtual. And this is a good time to get that house in order. Finally, let's talk a little bit about the continuity of your business, particularly because if you're on this call, that business probably weighs heavily just on you. That business may just be you, and there are people counting on you. And the old saying about, what if I get hit by a bus is now, what if I get hit by a virus? We've all seen the stories that you could feel fine today and in 3 days be flat on your back and strapped to a ventilator. I hope, obviously, that does not happen to anyone. But if your family's counting on your business, or your coworkers are counting on your business, you need to be ready for that. You need to set up structures so that other people can get to the check in the mail. Other people can send money. Other people can check your email. And you also need to have the business itself configured in a way where it can continue to operate if you are out of commission, or if you go the way of all flesh. And for example, sole member LLCs, if you haven't made any other provision for it, if you pass away in 90 days, the business evaporates, it's gone. And in that period of time, it's not like whoever is your executor or your spouse can automatically run the business. They can't unless you have made some provision for it in the charter documents of your company. And just finally, a word about your legal duties. Typically, whoever runs a business, your duty is to your shareholders. For most of us, that means us, and the decisions we make are our own decisions in most cases. But if as a result of this disaster, your business is going downhill, and you think you may have to shut it down, or you may be in a world of insolvency, a world where you really don't see how you're going to meet all your obligations, your duties now shift. You may have a personal duty to your creditors. You will have a personal duty to any employees that you fail to pay. You will have a personal duty to any tax authorities, especially on payroll taxes, that you fail to pay. So suddenly it isn't just your money to do with as you think best. You may lose that limited liability you have by operating through a company if you do something like shut down and don't pay your payroll taxes. The government will come to you for those payroll taxes. So remember that as things get bad, you may have broader duties, and you'll want to take a look at them. And that gets us through my deck, and we can turn to Alyssa and Ayesha and your questions. Alyssa, I think you're still muted. There you go.
I know this by now. I think we got through most of the questions. So Anybody who is a sole proprietor and takes, you should wait till tomorrow to see what happens there. And then someone had a question in relation to some issues with the owners, but I think that you would have to turn to your Bank of America for that. It was about the owners being part of the loan, because you have to put each owner in for the loan.
I saw that one, and I would really hesitate to sign something that said I'm the borrower when I'm not the borrower, because suddenly it's 3 years from now, and whoever you were dealing with at Bank of America that you depended on to be a reasonable human is gone, and you're dealing with an 800 number, and you're trying to persuade them that even so you signed a piece of paper that said you were borrowing it, you weren't borrowing it.
Yeah.
And
hard to prove after the fact. Is that what you're trying to say?
I'm saying it's you. Good luck finding a human being, and without the ability to go to an actual human being in person and get them to say, yeah, you're right. The banks will run you around. That's their business model.
Yeah. Well, thank you very much. I think you answered a lot of questions that we had. I'm going to share my screen, and I'm going to just do some little bit of information quickly so we can get to Ayesha. So one of the questions we ask is, should you apply? So everybody keeps asking, there's different things that are involved in it, but one of the things is it's two different loans. The EIDL is supposed to cover 6 months of operational expenses. That's what it was created for. And the PP loan is for payroll. So, should you apply? One of the questions you have to ask yourself as a business owner is, was your business disrupted? And then the second question is, can you prove that it was disrupted? They haven't come up with any guidelines. So this is really a best guess. And we're always preparing for the worst and hoping for the best. So you would need to show a decrease in sales, an increase in accounts receivable because people aren't able to pay you. Or is there some other measure? Have contracts been delayed? Did one of your clients say to you, I can't sign this given the current climate? Did they come to you and you already have a contract and they said, we can't start yet, we have to wait 6 months to start because of the current climate? Things like that. If you can get emails, any documentation you can gather to say this has disrupted your business. And then it says the actual economic injury will be determined by the SBA. Another thing that you need to think about is, maybe you're okay right now, but is it going to disrupt it in the future using the previous measures? If your business is based on other businesses that aren't affected yet, but could be if this goes on for a period of time, should you apply to have the money? Just things to think about when you're thinking about applying, and if it makes sense. There are businesses out there that absolutely are not applying. One in particular, are a lot of landscaping companies are still doing great. They're still working because they're outside. They don't interact with other people. If it's a small enough crew, they're not interacting with each other. They can do their work and they're not being affected, which is great. So, and there's other industries that are really actually thriving in this. Amazon is thriving in this. So, and just a little different, when you apply for the EIDL, it's right on the SBA site, and we're going to post in the chat the link so you can go directly to it. And like Jason said, it takes 10 minutes to apply. They don't ask for any financial documents. They want to know about you and your business. They want to know your personal information. And then the PPP is through the bank. And as Jason said too, make sure it's with a bank that you know and you have a relationship with. Okay, so now you've applied, now what? So very important, and if you're one of our clients, we already have this set up for you, but if you get one of the loans, you need to track the expenses against it so that you know where the money was spent and you can prove where the money was spent. So if you do get both loans, track them separately. And what you want to do is track payroll, rent, health insurance payments, utilities, 401k costs, your mortgage interest. You're going to collect all the documentations from the third parties. I'm sure normally you just pay your rent, but I would request a rent receipt. And if you can, if you have electronic software like QuickBooks Online, which is what we use, you would attach the documentation to that transaction. And that way we can just pull that information through reports and download it and be able to provide it to your bank when it's time to ask for forgiveness on it. And don't forget that forgiveness is only up to 25% of rent, mortgage, interest, and utilities for the PPP loan. And then when you do apply, and I think this, and I know it's hard because it's online and a lot of times you can't ask questions, but if you can speak to your lender, ask them what they are asking for requirements for forgiveness. Every bank that we've dealt with has asked for different documentation to apply for the loan. There's not one set of rules. This was put together very quickly. Everybody's doing the best that they can, and banks are going with what they know. So ask your bank what they're going to ask for when you're going to ask for forgiveness, and ask them to send it to you in an email or where you can go to find this information and document everything. If I know both of our panelists on here today will agree with me about documenting everything that you can. Do we have questions or? I think we're. Most banks are waiving late fees. Okay. And yeah, it's just raining here and thunder's coming on. So Ayesha, are you ready? You can share your screen when you're ready. And oh, I'm sorry, Danielle's going to share her screen. And Ayesha is going to turn on, she's going to unmute herself.
Can you hear me?
Now we can.
Thank you.
And Danielle, can you share your screen with Ayesha's materials?
You know what? I'll get going, and then I'll ask for her to put up the slide when we get to that point.
Yes, I'm ready.
Well, perfect. So I apologize for being late. I had a court appearance that was scheduled for 10 and then 11:45 and started at 12:30. So it's been one of those days. But let's talk quickly about the employer side of this magnificent time that we're living through right now. I'm trying to be positive, as I hope all of you are as well. And just as a sort of disclaimer ahead of time, I'm going to be talking about a lot of the laws that, as Jason mentioned, are changing minute by minute. But also, this isn't meant to be specific advice to each of your companies. This is generalized advice. And so, you know, every situation is different. So what I've done over the past 3 weeks is spent my days fielding phone calls from small businesses asking about how the Families First Coronavirus Act applies to them. How does that interplay with the New Jersey Paid Sick Leave Act? How does the FMLA extension apply? So let's talk through that, okay? So if you have 500 employees or less, my guess is everybody on this call has 500 employees or less. You are subject to the FFCRA, okay? So that's the CARES Act. You're going to have to comply unless you believe that you qualify for the small business exemption. So Danielle, if you would put up the slide for the small business exemption, that gives us just a brief outline of what the Department of Labor is considering to be the small business exemption. So if you have a small, if you have 25 or fewer employees, in some guidance it says 50 or fewer employees, but what you're essentially going to have to do is prove that your expenses, by complying with the FMLA extension, which is providing the 2/3 of pay to an employee who claims that they cannot work and cannot telework either for up to 10 weeks. And what you'd have to say to the Department of Labor is, you can't make me comply with this because it would raise my expenses over my revenue. The Department of Labor guidance has said you don't have an obligation to go out and get loans to be able to continue to operate and comply, but just based on the finances that you have, your expenses would increase over your revenue. So they're not requiring you to make a loss or to take on debt to be able to comply with the FFCRA. The second category is where compliance would pose a substantial risk of threatening your employer's financial health or operations because of the employee's skill set. Ties in very closely with the third element, where the employer who's asking for the leave is really not easily replaceable. You could say to that employee, listen, I really can't let you not work. Interestingly, a lot of questions that small businesses have had is employees reaching out to them to say, I don't want to come into work because I'm scared I'll get COVID. And you've been classified as an essential business. The problem with that is fear of catching COVID is not a covered condition. You would have to have a doctor's note that says you're in a compromised immune system, or that you need to stay home to care for someone who's in quarantine. You'd have to somehow certify that as an employee, you're not able to work or telework. And then the employer might at that point be able to say, well, I cannot honor your request because I really need you here. And then, what you're really putting yourself in the position of is having the employee say to you, well, that's it, I quit. I'm not coming in. I'm not risking my health. I'm not risking bringing contamination back home to my family. So I'm not going to come in. At that point, your employee is going to have to then somehow certify to unemployment compensation that they quit for a COVID-related reason, and they're going to have to make the same level of proof that they would have had to present to you that they are not able to work for some specific reason. And we'll go through the unemployment compensation part of it a little bit later. So there's two categories of leave that you need to think about. There's the paid sick leave, which is in New Jersey 40 hours, or from the federal level 80 hours. And then there's the FMLA extension. So when you're talking about paid sick leave and talking in terms of the 1 week or 2 weeks of leave, essentially the categories are so broad that you're going to get that. You're going to have to grant that leave to the employee. There's really not going to be a whole lot of wiggle room in not paying that leave. It's when you get to the 2/3 pay for up to 10 weeks that you're really looking at some very specific, narrow guidelines provided by the Department of Labor. And it's almost that I can't come in because my child is home because the executive order has closed schools. That's about the only really detailed scenario where someone is going to get the 2/3 pay for up to 10 weeks. The other scenarios that the Department of Labor have identified for us are if you're in quarantine or subject to an isolation order yourself, if you have a note from your doctor saying that you shouldn't be coming into a public space to work, if you have COVID symptoms or you're seeking a diagnosis, if you're caring for an individual or are in self-quarantine as certified by a physician, or any other COVID-related reason that's identified by the Department of Health. Those are really the situations where the employee absolutely just has to trigger any one of those situations and they get their 40 hours of New Jersey paid sick leave plus the 80 hours. Now, there have been some questions about does the New Jersey sick leave, does the employee get the full 40 of the New Jersey sick leave? And what you're going to need to do is look to your handbook. So if your employee handbook said you accrue 1 hour per 30 hours worked, then that's the measure of what the employee has accrued as of the date that they're requesting the leave. You may want to just front load the 40 hours and give this to the employee since it's a medical related situation. And in fact, when we were chatting and preparing for this program, you know, my perspective on how you handle this is once this emergency has passed, you want to be up and running again with your team of people that you like and respect and have had on the payroll. So don't be an asshole. I said I would clean it up, I didn't. It's important to just have the, have sort of the foresight of saying, listen, especially if I'm going out for a payroll protection loan, especially if I'm going to get a grant, let me try and make this okay for my employees. One of the ways you can do that is you don't have to keep them on the payroll if you're not able to afford to do so. And nothing in the CARES Act requires you to keep somebody on the payroll if you cannot afford to do so. So then comes the question of layoff versus furlough. If you're looking at a company that may have 500 or fewer employees, but that has a union contract, you're most likely going to fall into the furlough bucket. A furlough represents sort of a promise that you will bring everybody back to work. My advice to private entities without a union contract is just call it a layoff. That's going to allow the employee to go off and get their unemployment compensation benefits, hopefully even the enhanced benefits if they haven't, if they've worked with you long enough. But you also want to see if there's something you can do to assist them, maybe in terms of a severance benefit. So it doesn't necessarily have to be weeks of pay, but you may consider, because this is a medical emergency, some form of COBRA reimbursement for a month or 2 months, so that these employees are not without income and also without a COBRA payment, or having to also pay COBRA payments that can be quite significant during the midst of a medical crisis. That's just food for thought, something you may want to think about as you handle going through transition right now, which I know a lot of us are. One of the things that the CARES Act requires is that you provide notices to your employees of their rights and responsibilities and obligations under the CARES Act. So if you're an essential business, you're going to have to post a poster. The posters are available on the US Department of Labor website. But if you're working remotely, that doesn't mean you're relieved from the obligation of providing the notices, because you're still operational. You're just operational remotely. So send those send the notice by email. I think it's important that you do that to just show full compliance. I mean, we can deal with a couple of questions so if an employee comes to you, they've been working and they say, listen, I'm no longer able to come in to work. It's okay for you to ask why. It's okay for you to ask what their concerns are, and then to request a physician's note. So early in this process, so 3-4 weeks ago, there'd been a lot of dispute amongst employment lawyers on whether it violated the ADA to be able to ask for a physician's note or not, because this isn't a medical emergency and you want to ensure that your workplace is safe and healthy, especially if you're an essential employer and you're having people come into the location, and you have OSHA obligations to maintain a safe and healthy workplace. It's okay to ask for a doctor's note. If someone tells you that they're being quarantined, you can get documentation. Every municipality has a Department of Health. That local health department is going to be the one putting you in quarantine or advising you of the need to self-quarantine. You'll have paperwork that you're able to provide to your employer. And it's okay for an employer to ask for that paperwork, especially if that's going to trigger a payment obligation. If an employee says, you know, they need to stay home to care for their child, they're going to get that leave. There's not a whole lot of wiggle room with that. The question recently has been, do I have to require my employees to use all of their accrued and unused PTO time before I have to pay them the 40 hours or the 80 hours? There is not guidance on that from the US Department of Labor at this point. So proceed cautiously. If you're intending to bring these employees back to work and they're presumably, let's say, hopefully coming back to work June 1st, they still have half a year, maybe allow them to retain that PTO time for the balance of their working year and just pay out the 40 or the 80 hours as applicable. It's really important, especially if you're working remotely, to do a quick employee training that says your handbook policy still applies. I would review good etiquette in terms of Zoom conferences. It's okay if you're wearing pajama pants, but listen, you represent the company. Please be appropriately professional. I have participated recently in some extremely fun Zoom happy hours that seem to take an interesting turn. Be cautious. Zoom conferences are, as this one is, can be recorded. The impressions you're making with your employees and the leadership tone that you're setting is really critical, because listen, we're all working independently and we're all frustrated and getting bummed out about the situation that we're stuck in, but you as a leader have an obligation to show leadership. Honestly, Googling leadership in the time of COVID and you'll get a lot of material to read on the internet. But it is really important as the business owner to absolutely do a little bit of retraining on expectations in the time of COVID. Danielle, I have another slide on using or sort of working remotely, if you have that. Maybe I didn't send it to you.
You could do.
Oh, there it is. So it's really important, I think, to make sure when you're dealing with your employees, now more than ever, be super clear about what your expectations are on each of the work assignments that you're giving them. Allow clarification. Don't be impatient. Be really, really specific. You've already, by this point, we're 3 weeks in, you've already decided which of the job functions can be conducted remotely. But if you haven't done that yet, and as we're seeing increasing executive orders from our governor, sort of tightening the scope of who can be out, we're almost at the point of now having a full sort of stay home order coming soon. You may want to reevaluate whether working in your office is a good idea or not. Always keep in mind your OSHA obligations to make sure that you're able to comply and keep a safe and healthy work environment. Small businesses, whereas in the past seem to be exempt from OSHA, you are not exempt from the general duty to maintain a safe and healthy work environment. And that's the one that you'll end up getting triggered on if there are a lot of employees who seem to test positive out of one specific small business. Danielle, are you able to move? Oh, maybe I can't. No, you did. Okay. It's really important to make sure that and I've had this happen a lot with my clients, is their employees are not as careful about cybersecurity as they are. And so you need to do some really clear training about now all of these people either VPNing into your workplace, into your work servers, or using cloud-based servers, of really making sure that they're protecting your data, protecting it. You should have your systems in place to protect data in transmission, especially if you're dealing with any kind of sensitive information like social security numbers, job applications, and anything like that. You're really going to have to be careful about making sure you have cloud-based security that encrypts data in upload, download, and transmission by email. All of those obligations still apply. So it's really, really important. You're going to, be clear about making sure that everybody understands what the role is, what their role is. And finally, I think it's really important to understand that you have to let your employees know when they're doing a good job and when they're doing a bad job. You would have done that face to face. You would have done it in the office. It's okay to say to somebody, listen, I'm going to have to let you go for a cause, right? It's something you do carefully in a time of COVID. It's something you do so that it does not appear that you're just trying to fire them to avoid paying the 2/3 pay under the FMLA extension. But to be able to do that, you're going to have to carefully document performance issues. You're going to have to carefully document that you've had conversations, that you've asked that they fix their behavior or that they improve their work product, and that despite repeated conversations, that has not happened. Start thinking about this if there is an employee that you're particularly concerned about, because you're really, I think we're going to be in this work setup, this work environment for much longer than we ever expected. This isn't going to be the just, May 1st return. Let me see, I know that we are almost at the end of our time. So the guidance now also from the Unemployment Compensation Board is that if you were an employee that, and I think actually we have a slide on that as well, is if you were formed in a corporate form where you filed a K-1, where you took a salary, even if it's a quarterly salary, even if it's just something token, you will have paid into the Unemployment Compensation Fund, and hence you can apply for unemployment compensation benefits, even if the small business guidance on owners has not come out yet. You can still try and file that application. It seems as though the CARES Act is going to provide protection for those who worked on a 1099 basis, those who are gig workers. It seems like there is going to be protection yet, but there isn't a whole lot of clarification on how that protection is going to come through in terms of the unemployment compensation benefits. If you are in this situation, or you have a family member who's in a situation and you had been claiming unemployment benefits and might have exhausted your 26 weeks, you will still be eligible for the additional 13 weeks of unemployment benefits. And the enhanced benefit as well. So again, the Department of Labor in New Jersey has said that they are waiting for guidance from the federal government on how to handle owners who took a draw, but that they are asking that you start processing applications, and that they'll make their best effort to sort of process them as soon as possible. As of earlier this week, or even late last week, the New Jersey Commissioner for Labor and Unemployment said that if you had a standard W-2 type of employment relationship, your application would be processed and likely payments would start the following week, and that your enhanced benefit of the additional $600 if you qualified for same would be a separate check, because that one's coming from the federal government. So if you have applied as sort of what they called a clean application, you should be perfectly fine. If your application is more related to being a business owner, it might take a couple more weeks to apply to get the application approved, but they were optimistic that the federal guidance would be that 1099s, gig workers, and business owners would also qualify. So Alyssa, let me turn it back to you. If there are questions, happy to answer them.
So we do, someone put a question, they said furloughed employees are still able to collect unemployment. Is that correct?
That is correct. So you can collect unemployment as long as you can show that your usual income is not available. So if once you're furloughed, you're off the payroll. The furloughed characterization really is an indication of, as soon as we can, we'll bring you back. Okay. But you are still eligible for unemployment benefits. And depending on the company policy, depending on if there's a union contract in play, you may have medical benefits, but you still qualify for unemployment.
Okay. And then someone else asked, they're required, because they're an essential business, they're required to have their employees use the N95 masks. And, the company raised concern because, these masks are in such shortage, and she's concerned about giving them to her employees and, the medical field not having enough. What can she do? Does she still have to supply them with N95 masks, or?
Well, I think, so the first question I would ask is, where is that requirement coming from? Because I don't think they can mandate that you have, that you provide only N95 masks if there is no availability, right? So I would then switch to, I just saw a graphic, I'm sorry, it was on Facebook, but it was an indication of the N95 is obviously the best, but surgical masks provide 60 to 80% of the protection as well. And then it was sort of a gradation of what the next best options are. Don't hand out handkerchiefs and bandanas. I mean, maybe do a little bit more. If you can provide gloves, but also, look at what is reasonably necessary of your business. So I think this is the point in time where we look at what the law requires and what really makes sense in the moment. So if I have not seen any requirement that N95 masks be the only solution. So I would look at sort of what is my next best option that I can actually get a hold of. Because if I don't have N95 masks, or the preference is, and I certainly appreciate that we leave those for the healthcare workers. And so if office workers can manage with surgical masks and gloves, that's a good option as well.
Okay. Furlough workers, does it allow the company to still pay for the medical benefits? Or do they
it would. So in a furlough context, if you have a union contract, that there may actually be sort of an obligation to continue medical benefits for the furloughed workers. If you don't have a union contract, you can still, it's essentially a layoff, and you can, as a severance benefit, say, I'm going to pay your $300 a month towards COBRA that I would have ordinarily paid. I just can't afford to pay your salary anymore.
So you could still continue to pay for their health insurance.
It's almost a COBRA reimbursement. So when we negotiate separation packages, almost every package I negotiate has a built-in, the company will pay for COBRA for the period of the separation benefit. And so this is the same thing. There's no payroll, there's just the COBRA part of it.
Okay. I have a question, and this can go to either Jason or Ayesha. There's a company, and it's based in the US, but she doesn't have 12 months worth of sales, and she's not a US citizen. Is she still eligible for the EIDL loan? I know, that's a good one, isn't it?
I saw something about US citizens only.
It is on the questionnaire.
It does ask you, but
Yeah,
I don't know that it negates you from getting it. I didn't know if you had any further information on it. It's quite possible.
I thought I had seen something in the, I'm going to have to look it up, but I thought that it was only, at least the CARES Act benefits seem to only apply to citizens.
I mean, it's a short enough application that it may be worth filling it out and checking no and seeing what happens. The other thing you could try to do as an experiment is go to that New Jersey benefits wizard. I think it asks about citizenship and see what comes out the other side.
Okay.
The thing also is, if you have a social security, so you don't have to be a citizen, I believe, to have an EIN number or social security number.
It's true.
So you may just try.
Yeah.
I mean, it's a US based company. They're doing business in the US.
And if he has an EIN number, I think that might control, because she's paying US taxes too.
Right.
So quote unquote, the policy behind it is you've paid into the fund.
Right.
you should be able to claim it. Just because one of the
Mhm.
individual members is not a citizen should not preclude you. It does, the citizenship thing, I'm pretty certain, precludes you from individual benefits under the CARES Act, but that may not be the same of corporate benefits under the two loan programs.
Interesting. Okay.
I have a couple of questions for Ayesha, if I could, or at least to have you weigh in on them. So one is picking up on one of the questions in the that's been typed in, which is about the, I talked about, okay, well, how do business owners apply for PPP or EIDL? But what about the relaxation of unemployment within New Jersey and the ability of a business owner to apply for unemployment on themselves, especially if, let's say, they're just taking a draw, they haven't been paying themselves W-2?
Right. So the current Department of Labor from the US and the New Jersey level are saying if you're a business owner that took a salary, you're going to get unemployment benefits because you had a W-2 fact pattern. If you do not have a W-2 fact pattern, which means you only took periodic draws, they're saying it's not ruled out. It's just that they're waiting for guidance from the federal government on how they're going to handle that, which is tomorrow. But they're saying apply anyway. And so what the commissioner for the New Jersey Department of Labor was saying, we're going to hold aside those applications, and as soon as we get guidance from the federal government, then they'll start processing them. My guess is that if they are processing, and they've said that they will already process applications for gig workers and 1099 workers and other sorts of independent contractors, you're probably going to get some form of benefit as a business owner. What you're going to have to demonstrate, as Alyssa had pointed out, is you're going to have to show a drop in your income. So compared to 2019 numbers, right? So this point in 2019, I would have taken a draw, maybe a monthly draw, maybe, I usually paid myself at the end of the quarter, X number of dollars. I don't have the cash flow to do that now. That may potentially carry the day, but we don't know.
Okay.
Yeah, so some of it comes into whether, you have an income that stopped.
Right.
As opposed to just, you thought you were going to make money and you're not. That to me is more of an EIDL situation.
Yeah, and Jason, you had mentioned, you're expecting a contract to come in. Everybody is freezing on new business right now, right? So everyone is feeling that crunch. I think those are more of the corporate benefit. I think of it as the individual benefits under the CARES Act and the corporate benefits under the EIDL and the PPP. That's going to be more of a corporate benefit that you're probably going to be okay on, right? If you show, I think, substantial progress towards the finalization of a contract, that you were everything short of signatures, and then COVID hit, that you might have a good argument.
And then my other question for you that also picks up on what I'm saying in the text is, Ayesha's, how does she and I differ in our practice? One big one is Ayesha goes to court, and I stopped litigating a while ago. Hence the suit. So, what's the state of the courts, particularly in New Jersey, for things like, landlords going to court, people enforcing to get collections? You could see that being, you could see a court slowdown or stoppage being, either a godsend or a problem for a business, depending on what's, are you plaintiff or defendant? But sort of, what's the state now, and what does it mean to some of these decisions in terms of, my landlord might evict me, or I'm trying to collect something?
So as a general matter, all court buildings are closed. There's been some reopening for emergent matters, but there is an executive order that puts a stay on landlord-tenant evictions, foreclosures. And so we want to make sure that, if you're on the landlord side of things, check the executive order, just make sure you're not running afoul of that. Also, just keep in mind that everybody's hurting right now, and that, an eviction process right now may not necessarily be the right way to go. The other part of that is courts are as I was, earlier today, they are doing hearings on Zoom conference. They're putting off a lot of hearings. So a judge will take a look at it and determine sort of, is this emergent? Is it not? And essentially put it off. You're not, we're not on the same sort of motion schedule. Things are not quite as aggressive as they would be if we were in pre-COVID times. However, if you have an issue that you can make a good case for a judge requiring in order to show cause hearing, something emergent, they are still hearing these things. They are hearing them by Zoom. I have a colleague who is doing a domestic violence trial on Monday, doing this by Zoom conference. These are things that, life does have to go on. But whereas the courts were very aggressively cautious about not having a huge backlog, we're all sort of a little bit more relaxed about it now.
Mm-hmm. So, if my copyright's being infringed, go for it. If I'm talking about special civil part collections for a couple $1,000s, you're probably going to do better or just making a deal with somebody.
Yeah, and part of it is, I know that, and to sort of give a shout out to court representatives and judges, they're figuring this stuff out as we go. I had a motion hearing 3 weeks ago on Friday where it was by phone conference, and it was horrible because other attorneys kept cutting in because they just had one phone line for the courtroom. Now they have Zoom conferences where everyone's placed in a waiting room and things are running much better. So I ask that, as litigants, right, as parties who may want to file suit or who are having suit filed against them, be patient. But if you have an issue that is emergent, it will be heard.
All right. Well, thank you both so much. We've had so much good information today, and we've recorded this, and we're going to make it available to everybody that attended the webinar. And all right, we have one last question from someone. For business owners that normally take S-Cost distributions, is there any relief for anybody who normally takes distributions? So it's the same as the owner's draw. Mm-hmm. Yeah, it's treated the same way.
And how if you're, the distinction seems like it's going to be, are you paying yourself a W-2 and paying withholding and paying unemployment insurance and all that other stuff, in which case, even though you're the owner, you're an employee. Or are you taking it as a draw, or, it's an occasional thing, in which case, we'll have to see exactly what happens when the new rules come out any second now.
Yeah.
But you could do worse than apply and see what happens.
All right. Thank you so much. And we're going to make all this information available to everybody. And everybody stay safe, and we'll catch up with everyone soon.
Take care, everybody.
Thank you, guys. Thanks, Alyssa.